Welcome back to the Emily Show. I know it feels like it's been a minute, but over on the Emily D. Baker channel, we have been very busy live streaming the Donna Adelson trial. And really, when the judge said this will be 3 weeks, including jury selection, boy, did he mean it, because that trial started on time and ended earlier than I thought it would, with what felt like a late night verdict on Thursday, September 4th. After a full day of closing arguments, the jury was out for about 3 hours, but we're going to talk about that more on live stream. So make sure you have the Law Nerd app so you know what's going on the live stream channel and on this channel and this podcast, because there is more court to cover that we missed while we were covering the Adelson trial, so don't worry. Today, we're going to be talking about some of that, and we're going to be peeking into not court, but an administrative hearing. It is court adjacent. Why? Well, former trooper Michael Proctor would like to no longer be former. So yes, today we are going back to Massachusetts to talk more about the fallout from the Karen Reed case, because former trooper Michael Proctor is fighting for his job back, and we need to talk about these administrative hearings because I got a lot of questions about it. So I'm going to catch you up today on what's going on with the administrative hearings, when they are going to be continuing, what needs to be proven, what the standard is, and what's happening from there. And then the other things happening in the world of Massachusetts in the Karen Reed case, because we've learned a lot more about how much the second trial cost the citizens of Massachusetts, and a quick update on the Karen Reed civil case. So as always, timestamps are down below to take a look at what you want to see most. We just need to get into it because we've got lots to cover today. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. A huge thank you to today's sponsor, Honeylove. I don't know about you, but the leaves are starting to fall where I'm at, and I'm all like, brr, it's cold in here. It's time for pumpkin spice and sweaters. And if you are also ready for cozy season, you know that finding the right underpinnings for sweater weather is important, because you don't want to be in your comfy, cozy fall vibes and be dealing with underwire that doesn't feel comfortable. Cozy should be all the way. And Honeylove makes the best wireless bras that feel like they are a second skin. They are lightweight and breathable, and they are designed to work with your body, not against it. Because you want your curves, but sometimes you just need a little support. So if you are ready to treat yourself to the shapewear, sleepwear, and yes, the most comfortable and innovative bras on the planet, now is the time, because Honeylove has got you covered. Of course they do. You're a law nerd. Save 20% off site-wide at honeylove.com/lawnerd. You can use our exclusive link at honeylove.com/lawnerd to get 20% off site-wide. And after your purchase, if they ask how you heard about Honeylove, let them know it was The Emily Show. And let's get back to it. So a quick TLDR on what's going on with former trooper Michael Proctor. All of you know that he was the lead investigator, or case agent, as they called him, on the Karen Reed investigation. He testified at the first trial. He didn't testify at the second trial. In between the two trials, he was terminated, which is not easy to do when individuals have civil service protection like police officers. So he was relieved of duty right after the verdict in the first Karen Reed case. And then all of that went through his civil service process with a recommendation ultimately of termination. And then he was terminated by state police. He is appealing that decision. So it goes to the Civil Service Board to determine whether or not they are going to side with or sustain the termination, or if they are going to recommend he be reinstated or receive some other disciplinary action less than termination, because that's what he's looking for. So the first question I've seen a lot of is, can this process undo his termination? Yes, it can result in his termination being overruled and him being placed back on duty. That is the rarer circumstance. It is more often that civil service sides with the employer, in this case, state police, than the employee, Michael Proctor, but it can happen. So what does this look like? It goes to a civil service commission, and the person sitting in the administrative hearing runs an administrative hearing. It is not a jury trial, but there are still rules of evidence, and things are weighed and determined by the hearing officer, not by a judge or a jury. But the parties have the ability to present evidence, and we're going to talk about 2 days of hearings where a lot of evidence was presented by state police. Because there is a burden on state police, first, to show by a preponderance of the evidence that the termination was proper. What that really means is that state police has to show that Michael Proctor engaged in misconduct that warranted the discipline, in this case termination, and that termination is the appropriate discipline. If state police meets that burden, that there was misconduct and it warranted discipline, then the burden shifts to Michael Proctor and his attorneys to show that the discipline, in this case termination, was not the appropriate remedy. So they have to try to prove that termination is too severe of a discipline and that another disciplinary action would be appropriate. So in this case, we are going to hear a lot about other officers, about text messages, because Michael Proctor and his attorney are really trying to narrow the scope of this to text messages. They are trying to narrow this case into he was terminated for personal things that he said that are distasteful. He's apologized, but he shouldn't lose his job. No one loses their job over personal text messages. State police is saying, okay, there were text messages, but there was more than that. And we're going to go through the opening statements of both sides, and you will see those arguments so that you can see that state police is not just terminated Michael Proctor based on text. It was based on other findings as well. And I covered those, and I will link the video where we went over his termination down below. Often civil service sides with the employer. However, there are times when civil service doesn't and says, yes, you know what? All officers have to be treated similarly. What is going to be difficult for the department with regard to the text messages is that there isn't really a policy about a personal cell phone. This circumstance is somewhat of an anomaly because officers' personal devices being discovered in a court proceeding like this is incredibly unusual. Emily, everything with the Karen Read case, you're like, this is incredibly, it is. It's incredibly unusual. It's very odd that there is a state level prosecution going on and then like a federal investigation with the FBI and all the rest of it. It's just unusual. But what we learn in these hearings is much more about when Michael Proctor found out that his personal text messages had gotten out there, because it seems like he was unaware and he was caught by surprise in February of 2024. Emily, the Karen Read case went to trial in April of 2024. Yeah, all the federal stuff came to light very quick in time to going to trial when he was at the grand jury. Michael Proctor didn't know they had his personal text until he went to testify at the grand jury. And the attorneys all didn't find out about it till well after that. It looks like March. All of the Proctor text messages, it seems, came to light to the defense and prosecution fully a month or a little bit more before the first Karen Read trial. No wonder the prosecution seemed like they were scrambling. This happened so close in time to when it went to trial. It makes sense why they all asked for a continuance. I mean, the judge didn't give it to them for the first trial, but they all asked for a continuance. They're like, we agree. And I'm like, well, it's really unusual that if the defense and prosecution all agrees for a continuance, that the judge wouldn't grant it. And then, of course, the judge didn't grant it. So there we go. So the first 2 days of hearings took place August 26th and 27th, while we were all in Tallahassee, Florida with Donna Adelson. But it's not done yet. There's still 3 more days of hearing to take place in October. And if you want to go over those live, let me know and we will cover them. And then all of you are going to be like, I hate this so much. Administrative hearings are boring. Yes. But it's going to be Michael Proctor's case in chief in October. So it's going to be his witnesses. Emily, why don't they just have his witnesses now? Oh, dear law nerd. Because Michael Proctor and his lawyers are complaining that they haven't been given discovery from state police yet. So they say they don't have all the discovery that they need. And they can't bring their witnesses until they have all the discovery. Yeah, I know. The irony. It's so frustrating when you don't have the discovery that you need. Weird. And for all of you that have been following along the other Michael Proctor prosecutions, this is an ongoing issue in all the discovery hearings we've been watching, where the defense attorneys are like, hey, it's been years. Where are basic things like the search warrants? So let's take a look together at the opening statements that are going to lay out what each side is going to be arguing over these hearings. And just keep in mind, these are part of Michael Proctor's due process rights. And one of the interesting things about law is being able to try to keep an open mind, even with defendants that are not your favorite. And we are watching the due process for Michael Proctor play out. And it'll be interesting to see what happens. So let's go to the opening statements. First, from the lawyer from Massachusetts State Police, who are defending the fact that they fired Michael Proctor. And then to Michael Proctor's attorney, who is saying, no, this should be overturned and he should be reinstated. And just a little law nerd note, I'm going to play this at normal speed, but if you are a sped up law nerd, they talk very slow. Just hit the 2. Let's go to opening statements from Massachusetts State Police.
Distasteful. Unprofessional.
I mean,
inappropriate. In poor taste. Juvenile.
I wonder where he's pulling all of these from.
Sexist. Disgusting.
He's going to say all the words.
Dehumanizing.
Yep.
This selection of words does not come from a public comment section on a website, an op-ed columnist, or a protester outside the Norfolk County Courthouse.
I mean, there's been a lot
indeed.
of those.
One would be forgiven for not immediately recognizing that these words are Michael Proctor's accounting of his own conduct in this case.
Oh, we knew exactly where those came from, sir.
Conduct in which Michael Proctor, tasked with the immense responsibility of acting as case officer for the investigation into the death of John O'Keefe, consumed alcohol and then operated his cruiser while on duty.
The incident that he is talking about did not occur during the investigation of the Karen Read case, but it was discovered because of the text messages during the Karen Read case. So when the text got out, the text messages referenced back this incident that it came up during Michael Proctor's testimony in the Karen Read first trial. Proctor and Kevin Albert from Canton PD were out at the Cape investigating some other case together. And then there were text messages afterwards because Kevin Albert left his service weapon and his badge in Proctor's car because they had gone out to dinner and were drinking together. And then Proctor, after having drinks, drove his cruiser while they were on duty and dropped Kevin Albert off. Because of all of that, Kevin Albert was suspended without pay for 3 8-hour shifts after an IA investigation into all of this, which again came to light because of the text messages, because Kevin Albert was texting Michael Proctor all on their personal cell phones, being like, dude, where's my weapon and badge? Wicked bad hangover today. So that's what he's referencing. That occurred during a separate investigation, but it was in the text and that's why it came up. Back to opening statements.
Released confidential information
to his friends,
individuals outside of law enforcement,
and his sister,
and called suspect and eventual defendant Karen Read,
oh gosh,
a babe.
He's gonna say all the things.
A nutbag.
Just warning, warning,
retarded.
Warning.
A whack job.
There's more to that phrase.
She's got a leaky balloon knot.
Yeah.
Leaks poo. A woman who shits herself.
Yep.
With no ass. She's fucked.
Oh dear. He was definitely making sure that the hearing officer knew all the things that Michael Proctor said about Karen Read in those text messages and trying to put as much emphasis on them as Alan Jackson did. We will bleep what needed to be bleeped appropriately, but you watch the trial, you know what he said. Remember, they're your words, say them.
As a result,
yep,
the department brought forward 4 separate specifications within 2 types of charges for internal discipline.
It's not just the text messages. There were 4 different points that discipline was determined was appropriate for, not just one thing. Though most of the things he was disciplined for came to light because of the texts, it's not singularly about what was said in the text.
In March, Colonel Noble terminated Michael Proctor's employment.
That was March 2025.
In support of the just cause for doing so, beginning today, the department presents for your consideration its evidence of the appellant's guilt under the charges and specifications described as follows. Charge 1, Specification 1, unsatisfactory performance, sending derogatory, defamatory, disparaging, and inappropriate text messages about a suspect.
Yep.
Charge 1, Specification 2, unsatisfactory performance, provision of sensitive and confidential information about a homicide victim, potential witnesses, and potential investigative steps to non-law enforcement personnel.
His friends, his sister.
Charge 1, Specification 3, unsatisfactory performance through unprofessional and inappropriate conduct, created an image that he was biased and brought himself and Massachusetts State Police into disrepute.
Let me know if you think that was true.
And finally, Charge 2, Specification 1, consumption of alcoholic beverages while eating dinner on duty and then operating his department-issued cruiser.
Yep.
The department's defense of the just cause of the adverse employment action against Michael Proctor will be based entirely upon the evidence of his conduct, his violations.
I mean, he
those
admits all of it.
Under our Article 5. To prove this case here in this de novo proceeding, the department will call OPIA Detective Lieutenant Kevin Dwyer, who was assigned an investigation initiated by DIS Commander Lieutenant Colonel Brian Connors.
That's the IA investigator.
In addition to the testimony of Detective Lieutenant Dwyer, the department has submitted and has been entered into evidence for your review and consideration those 36 exhibits, demonstrating by a preponderance of the evidence that Colonel Noble had just cause to terminate Michael Proctor's employment. You will hear of Detective Lieutenant Dwyer's collection and assessment of the records of the appellant's misconduct, first brought to light in excruciating detail during 2 days of his public testimony at the homicide trial in Norfolk Superior Court on June 10th and 12th of 2024.
And what he said under oath is most of what they use.
Hear the appellant read in his own voice his vile, misogynistic statements against the woman accused of and tried for the death of Officer O'Keefe. You will have the opportunity to hear his revelations to high school friends and members of his family of the identity of the victim, his views on and details of the crime, the manner of the victim's death, the witnesses to be interviewed, and the direction of that investigation, some made under 24 hours of the discovery of Officer O'Keefe's
a lot
body.
of them made within like the first 16 hours.
You will hear his own characterizations of his conduct that I quoted to you before. And you will hear his admissions under Charge 2 that while he was on duty, he consumed 1 to 2 beers with an officer from Canton Police and then drove the 2 of them home.
That was Kevin Albert.
You will be given, in addition to the video recordings of that public testimony, transcripts of the appellant's own words for your review and reference, a summary of Detective Lieutenant Dwyer of his misconduct, of Michael Proctor's misconduct as revealed during the trial, pay station, administrative duty roster, and AVL data collected by Detective Lieutenant Dwyer, corroborating the appellant's account of his alcohol consumption while on duty, the statements and admissions by the appellant at his OPIA interview, and Detective Lieutenant Dwyer's conclusions therefrom.
That is...
as well as the criminal trial exhibits.
The interview is the IA interview. The other exhibits are from the trial. And yes, in this hearing, they played a lot of the cross-examination with Alan Jackson and Trooper Proctor from Karen Reed Trial 1. They also played some of the direct examination because Trooper Proctor admits, yes, I wrote those texts. Yes, I said those things. They're juvenile. They're regrettable. They're distasteful. Yes, I did those things. So all under oath, all his trial testimony, in addition to his IA testimony.
Themselves containing the appellant's messages. You will also have available for your consideration the findings and resulting recommendation of the department's internal trial board, as well as the limited selection of public reaction to the revelations of the appellant's
I don't know if the public reaction matters all that much.
Of an interview he gave to ABC News following his termination.
Ding, ding, ding.
And an order from the Norfolk County District Attorney's Office for him to turn over as discoverable statements in a criminal prosecution under Rule 14 the content of his communications from his personal cell phone. The department expects that much by way of distraction will also be on offer in the days to come, in the form of dubious and flimsy comparisons, whataboutisms reflecting the choices of others, spurious emotional appeals to the absolutely real difficulties experienced by members assigned to a homicide investigation, and insinuations that written statements by a case officer regarding his own investigation are somehow private or out of bounds. In short, The department expects an appeal not based on the truth, but on evading accountability.
Oh, he's going right after what he thinks they're going to say, huh?
That this commission, while receiving those distractions or attempts at same, keep in mind the evidence and the facts.
Ooh, straight for the
basis
facts.
For the department's case. It respectfully asks you to bear in mind that no one committed the acts for which he was terminated other than Michael Proctor alone. No one authorized his communications of sensitive and confidential case information about an active homicide investigation to others outside of law enforcement. No one forced or cajoled or even requested him to engage in such gratuitous behavior, and that Michael Proctor himself has admitted, as evidently he must, that his conduct was unprofessional, inappropriate, juvenile, sexist, disgusting, and dehumanizing, and that he has admitted that he in fact committed the acts exactly as described
He did do
in the
that.
charges brought against him.
Yep.
Accordingly, at the conclusion of this hearing, the department expects to meet its burden, showing just cause, and will therefore ask this commission to uphold the termination of Michael Proctor.
The lawyer from state police is saying, keep him fired. Thank you to today's sponsor, OneSkin. You've heard me talk about OneSkin for their all-in-one skincare and their sunscreen. And today I'm sharing a newer product from OneSkin. They launched a scalp serum. I know. One of the things I love about OS1 hair is that I can use it every day, but it does not make my hair look oily. And I love that it doesn't change my routine while improving my scalp health. So let me tell you all the things people are saying about OS1 hair. OneSkin has put their patented OS1 peptide into OS1 hair to target hair loss and thinning. And a clinical study has showed a nearly 40% increase in hair density from using OneSkin's scalp serum. And in a consumer perception study, 75% of people noticed new hair growth after just 3 months. The Launer discount code applies to a 3-month supply of OS1 hair so you can see for yourself. OS1 hair is drug-free, prescription-free, and makes your scalp feel healthier and more nourished. You know that OneSkin is the world's first skin longevity company, and they focus on the cellular aspects of aging, keeping your skin looking and acting younger for longer. So for a limited time, you can try OneSkin with 15% off using code LAUNERD at oneskin.co. That's 15% off oneskin.co with code LAUNERD. And go ahead and try the OS1 hair and let me know what you think. After purchase, they're going to ask you where you heard of them. Just let them know it's The Emily Show. You know who's not going to be using OS1 hair? Trooper Michael Proctor. Let's get back to today's episode. And we will move on to Mr. Moynihan, Trooper Proctor's attorney.
Commissioner McConney, Mr. Queenan. We're here today to hear evidence presented by the Department of State Police, which it believes
every size water bottle you can find on that table.
Proctor. Due to the fact that we continue to await discovery from the department, you will not hear a presentation of evidence by Michael Proctor today or tomorrow. You won't hear about his presentation of our evidence until October.
Because they're waiting on discovery.
We will, through cross-examination, get to the truth behind this case. And the truth is that as of February 1st, 2024, Michael Proctor was an exemplary member of the Mass State Police. He had served in that capacity for 12 solid years without any discipline. He had risen to the level.
You're doing your job, but it begs the question, how do we have so many cases where discovery just goes undiscovered by the attorneys who need it? Because the cases that we're looking at now predate 2024. But he was saying up till February 2024, when the checks were discovered, not when they were written, never been disciplined. And that's true, which raises other questions.
Of the ranks of detective for the Norfolk County DA's office.
So you're going to hear about Proctor's
trooper
work.
And served in the role as detective and was a very well-respected member of that unit. As of January 29th of 22, Michael Proctor,
when he got
a
the
fairly new
investigation
detective in the DA's office, was asked to become the case officer on the Karen Reed case.
How? You have they knew that the victim was a Boston police officer. How does the new guy get assigned that case? It defies logic to me. But him being new still doesn't excuse all the things that they're going to try to excuse.
You will hear what his duties were as case officer and you will hear all that he was not responsible for as case officer in this case. Now, as we all know, Karen Reed was arrested, she was indicted by a grand jury, and she was tried twice by the Norfolk County DA's office.
And then acquitted.
2022 through 2024.
And largely acquitted.
In the early part of late 2023 or early 24, the defense in the Karen Reed case
Counsel's looking right at the camera. The commissioners are sitting in front of him. He keeps looking at us. He's not looking at the decision makers.
Convinced the U.S. Attorney's Office to open an investigation.
This is interesting to me. Counsel begins to tell us that somehow the defense, Karen Reed's defense, Yannetti, Jackson et al., managed to coerce the U.S. Attorney's Office to open an investigation. I generally find the feds uncoercible. We're going to learn more about what went down in the federal investigation than I have heard through the course of the two trials.
Late 2023 or early 24, the defense in the Karen Reed case convinced the U.S. Attorney's Office to open an investigation into a theory of a grand conspiracy against Ms. Reed on the part of law enforcement and others. You will hear that Michael Proctor was asked to testify in the federal grand jury proceeding as a witness only on February 1st, 2024. And when he appeared, he was shocked to discover that the U.S. Attorney had somehow infiltrated his personal cell phone and surreptitiously obtained personal text messages on his personal cell phone.
Counsel just said that Proctor went to testify at the federal grand jury about the Karen Reed case as a witness, February 1st, and the words he used were, and found out that the U.S. Attorney's Office, well, it's not really the U.S. Attorney's Office is doing that. I mean, they're working with the FBI, of course, but they, quote, surreptitiously infiltrated his personal text. Counsel, they got subpoenas with probable cause. Surreptitiously infiltrated his phone. That's strong language, isn't it? But also, isn't it wild that Proctor shows up and they're like, can you explain this? And he was like, what? Dude, Scotty didn't know. It's wild to me.
We all have personal cell phones. We all have expectations of privacy on those personal cell phones. On February 1st,
until somebody gets a warrant,
Michael Proctor suddenly found in his mind that his privacy was violated. Since the disclosure of these text messages, the world has changed. Law enforcement officers and people in all walks of life now shudder at the thought that a federal agency could infiltrate their personal phone and look at text messages, personal text messages on a personal phone to family members and friends.
First of all, if they're going to use the text messages, etc., and subpoenas aren't getting quashed, it's because they had probable cause. Also, what U.S. agencies have access to what is much a concern. However, if there is probable cause, it's not been infiltrated in violation of your client's reasonable expectation of privacy. See, that's overridden by probable cause. I have a lot of questions about what he means by infiltrated, and if he means infiltrated without a warrant, I got some questions if that's the case. How did they get to Proctor's texts? I would love to know.
Michael Proctor has reacted to this unlike many other people would. Michael Proctor has never denied the authenticity of these text messages. He's never denied that they are inappropriate, unprofessional, derogatory, sexist, misogynistic. Despite the fact that he's never, to this day, received the full text threads numbering hundreds of thousands of dollars that the U.S. Attorney's Office obtained.
It's his phone!
And despite the fact that he still doesn't know why
He said there's hundreds of thousands of texts. I think he said dollars, but I think he means text. It's his phone. Look in your phone. Look on your iCloud, wherever you back them up to. Go check, you have them. They've never given them to us. I think counsel's going to begin to address a question that I have, and I'm curious to see what he says.
U.S. Attorney's Office obtained. And despite the fact that he still doesn't know why his personal cell phone was infiltrated.
I'm very curious about that.
Michael has repeatedly apologized for making crude remarks, unprofessional remarks, juvenile remarks. We could come up with many other adjectives that Michael has admitted to. He has never backed away from apologizing for these these outright unprofessional and I'll call them stupid text messages on his personal cell phone spoken to his buddies from childhood.
But you were
Instead of backing away,
talking about things that were
what did Michael
confidential.
Proctor do? Well, the next day, he self-reported this information to his bosses at the Mass State Police.
Well, why would he do that? He reported it to his bosses because the shit was already out of the horse, counsel. He knew he had been clocked. Talking about drinking and driving his department vehicle on duty. Talking about Kevin Albert losing his service weapon and badge while they were drinking and being on duty. All the things he said about Karen Reed. Of course, he went to his bosses and were like, so about that grand jury yesterday, you're probably going to hear about it. Yeah, I bet he did.
The full context of these text messages to the Mass State Police, despite the fact that there's no existing Mass State policy concerning a trooper's personal text messages or personal private conversations on a personal cell phone.
You can't disclose confidential information, though.
From that point, you'll hear evidence of what happened next and what didn't happen next in the ensuing 5 months and up till March of 25 when Michael was terminated by the department. You will hear of a meeting which was initiated by Michael and his then counsel on February 8th of 24, I'm sorry.
So listen to the dates there. February 1st, 2024, he goes into the grand jury. Remember, the Karen Reed trial starts April 2024, the first one. And then he and his lawyer initiate a meeting with his department 5 days later. I wonder why.
Wherein the content of these text messages was disclosed to the legal staff of the Mass State Police, as well as high-ranking members of the Mass State Police. You will hear that the Mass State Police assured Michael Proctor that not much would come of this, and that he may receive a letter of counseling as a result, or a written reprimand, and that the colonel and the command staff expressed appreciation for him immediately reporting these text messages to them.
Mm-hmm.
You'll hear of a separate investigation done by the department in April of 24, wherein the nature of Michael's relationships, alleged relationships with witnesses was investigated, and the issue of bias was investigated, and their findings were negative. You will hear that Michael Proctor remained on full duty from February 2nd, when he first disclosed, until July 1st, which is coincidentally the date of the Karen Reed mistrial.
That's true. He was relieved without pay the day of the mistrial, but he had testified under oath. I am so curious if the texts that he disclosed were everything that came out in trial, or if more came out in trial.
You'll hear that after that mistrial, that unfortunate date for Mike Proctor, July 1st of 24, the witch hunt for Michael Proctor began.
That's a
He was relieved of duty
interesting
within
use
hours
of
after that
phrase,
mistrial.
counsel.
You'll hear a press release from the colonel at the time who stated, quote, "Upon learning today's result, Michael Proctor was relieved of duty." You'll hear of intense political scrutiny, intense media pressure to fire Michael Proctor. You'll hear that this termination was not based on actual facts and evidence. Instead, it was a decision made to appease politicians and to appease some vocal members of the public and the media. You'll hear of the so-called internal trial board process of the Mass State Police.
So-called?
And how flawed that process is.
The internal trial board?
It is, and lacking in due process. You'll hear that despite the flawed process of that internal trial board, this decision to fire Mike Proctor was made on July 1st of 24, within hours after that mistrial. Most important, you'll hear...
The reason he's bringing that up is because if the determination was made to fire Michael Proctor the same day he was relieved of duty without any due process, it might factor into the decision-making of the Civil Service Board, because there is a process that they have to go through and make findings, and they have to go through that process before they recommend what should happen. It wasn't recommended that he be fired until March of 2025, when they got through all of the trial board for Mass State Police to determine what would happen, if anything. And others involved in the case lost vacation days, had work without pay, and things like that. He was the only one terminated.
Evidence from the trial board in this hearing that Michael Proctor's personal feelings did not influence the evidence in the Reed case. Michael Proctor acted did not act with the intent to affect the outcome of this investigation. You'll hear that there's no evidence to show that the integrity of the investigation in the Reed case was compromised. In other words, the personal cell phone text did not affect his performance of his police duties. And that the Mass State Police investigation into Michael was solely about personal cell phone messages and not about his job performance in the investigation. And that the charge of unsatisfactory performance of his duties is a misplaced charge. It's a charge that was designed as a Class A offense simply to appease the masses and fire Mike Proctor. In summary, Mike Proctor was a very good trooper, an exemplary trooper, a detective who has been made to be a scapegoat as a result of the Mass State Police caving in to public pressure. Michael Proctor did not commit a crime. Michael Proctor did not violate any specific policy prohibiting personal conduct on a personal phone, because there is no
drinking and
specific
driving
policy. Those are two very important facts to remember in this case. Does his unprofessional conduct on his personal phone possibly warrant some discipline? Probably. Unbecoming conduct, possibly.
He's saying that that wouldn't be termination.
We will demonstrate, when we have our discovery, that the termination of Mike Proctor, the firing of Michael Proctor after 12 exemplary years, does not comport with previous standards of discipline for the Mass State Police, and that is disproportionate with discipline meted out by the state police over the years. Michael Proctor should not be subject to the whims of politics or the whims of the media. He should obtain a fair hearing on the merits, and we expect to obtain that fair hearing through this process. No one should be unjustifiably pushed aside from his job simply because an organization wants to satisfy an agenda. And that's what happened here, folks. Thank you.
Thank you very much, Mr. White.
And that is Michael Proctor's counsel's opening statement saying, look, he is entitled to due process. I agree with that. He is saying he hasn't violated any laws. He hasn't broken any laws. I have questions about the drinking and driving, but I don't know how much he drank. But you can't drive after drinking on duty, even if it wasn't to the level of DUI. And he was saying, look, Mass State Police does not have any policies about personal cell phones. However, they are going to have policies about not disclosing details of an investigation to non-police personnel. The fact that it happened on a personal cell phone is to the side of the point of releasing information about a homicide victim to non-department personnel and more. But his point is that others have been disciplined for unbecoming conduct without being terminated. That Michael Proctor being terminated was, as he said, politically motivated. We'll see, because they have 3 days set aside in October to present their side of the story. And I imagine a lot of their side of the story is going to be, but so-and-so wasn't fired, and so-and-so wasn't fired, and so-and-so wasn't fired, and so-and-so wasn't fired. And if that's true, and this discipline is out of proportion with how others have been treated, it will make the civil service process very interesting, because those are the types of situations where civil service says, no, employees need to be treated similarly when similarly situated. So we're going to have to wait to see, but I am sure other members of the department will not be thrilled if Michael Proctor is pulling all of their disciplinary actions into this hearing. We're going to have to wait till October on that. And in other matters, talking about Michael Proctor's text messages, some of you have watched the discovery hearings in the prosecution of Miles King and the prosecution of Brian Walsh, and the issue of Michael Proctor's text messages keeps coming up. You'll remember that the feds turned over all of the Proctor texts to Norfolk DAs under protective order to be used in the Karen Reed case and to be disclosed to the defense in the Karen Reed case. And they were under protective order that they could not be distributed, discussed, disclosed, discovered for anyone else. And in fact, the prosecutors on the Karen Reed case could not disclose those to the defense. However, because Attorney McLaughlin is also on some of the other cases that Proctor had worked on, she had information that needed to be disclosed to the defense and said to the defense, these things exist. I can't give them to you, but they exist. And we ended up in this really strange conundrum where the prosecutor says, hey, these things exist, and I think they're discoverable, but I can't give them to you, defense. And the defense is like, well, if you have discoverable information, you have to give it to us. And she's like, okay, but so there's a court order from the federal court saying that we can't give it to you, but I know it exists, so I can't not tell you it exists. And of course, because the Karen Read case was televised, all the defense attorneys know it exists. And so we end up with discovery hearing after discovery hearing about Michael Proctor's text, among other discovery. So at the same time these hearings were going on August 27th, the prosecutors filed motions in the Brian Walsh case and others. And now the feds have agreed that we can turn over Michael Proctor's text messages in, quote, any criminal matter involving former Mass State Police Trooper Michael Proctor. So the protective order has been extended from Karen Read's defense attorneys and prosecutors to any case that involved Michael Proctor. So now all of those text messages will get turned over, still under protective order, to all the defense attorneys in the Walsh case, the Miles King case, and others. Every case that Michael Proctor had touched that's still going through the criminal system is going to now be able to get these text messages under protective order. Any motions regarding the text messages will be filed under seal. So these will still be protected in some way, but the defense attorneys in those cases are not going to have to continue to fight for them, because it set up a very difficult issue of this is potentially exculpatory discovery. And the feds are saying that the prosecution can't turn it over. So do the prosecutors violate their discovery obligation and risk their state case getting thrown out for discovery violations? Or do they violate the federal protective order and deal with the fallout from that? It was an incredibly unusual situation. And it looked like the feds were going to continue to fight it because they said they were opposing the modification of the protective order. And then maybe the looming issue that these are numerous murder cases that could get thrown out on discovery violations for not turning these things over after they were central to not only a very public trial, but also now central to very public civil service hearings. It's kind of hard to put that, toothpaste back in the tube. Those defense attorneys will have that discovery. I mean, Michael Proctor is still waiting for his discovery from state police, but the defense attorneys will have the discovery of Michael Proctor's text at least. Speaking of the continued fallout from the Karen Read case, NBC 10 Boston has continued to dig into the real cost of the Karen Read case. We have talked about the cost of Attorney Brennan, which was almost $600,000. We talked about the cost of Aperture and Shannon Burgess with one N and no degree, and the blue paint and the rest of it. At trial, it came out that Aperture had been paid like $400,000. I can't imagine going to the elected DA on a retrial and being like, hey, so you've brought in a special prosecutor. It's going to cost you more than $500,000. Like more than I would imagine almost any prosecutor in Norfolk's annual salary, if not the annual salary of 2 or 3 or 4 trial deputies, and probably more than the elected DA as well. But you bring in a special prosecutor for over $500,000. And then to go to that DA and be like, hey, we need new everything for this retrial. Do we have a budget? And it's like, nah, we're good. I can't imagine. So now we're learning a lot more about how much the second trial costs. This does not include the cost of trial number 1. Trial number 1 is going to have costs like overtime at the courthouse to keep the crowds outside and the jury and the rest of it. Any scientific testing, though they didn't bring in nearly as many external experts, there is still a cost to a trial, especially a trial that is, 10 plus weeks long. But trial 2, man, trial 2, coming in at $1.4 million according to records. The bulk of the expenses went towards paying special prosecutor Hank Brennan and the costs associated with accident reconstruction work and testimony from the experts at Aperture. Let's take a look at where that went. The prosecution of the second Karen Read retrial will cost Massachusetts taxpayers more than $1.4 million, according to newly released records from the Norfolk County District Attorney's Office. For comparison, during the first Read trial, which ended in a mistrial, prosecutors spent around $45,000 for expert civilian witnesses from 4 firms: Bode, Hexordia, Venture 2, and UC Davis. UC Davis was the DNA on John O'Keefe's hoodie. They go on to say the bulk of the expense will go towards paying Special Prosecutor Hank Brennan, which cost was previously disclosed to be around $566,000, and to costs associated with accident reconstruction, work, and testimony by experts from Aperture, which billed close to $600,000. At trial, they said $400,000, and I was like, you've got to be joking. It goes on to say that the state paid out around $850,000 for forensic testing, expert testimony, court transcripts, travel, and other related expenses, according to the newly released documents. And that amount does not factor in other aspects like security cost at the courthouse. So the overtime and all the additional security is not factored into any of this. Oh, but the associated story is that apparently Elizabeth Banks is going to play Karen Reed in the new Prime Video series. I love Elizabeth Banks. Trial 2. Over $1.4 million. It's an awful lot of money on a DUI prosecution, isn't it? But apparently Elizabeth Banks is going to be playing Karen Reed. So there's that. Who do you think is going to play Hank Brennan or Lally? Who, if anyone? Whom, if anyone? Moving on. The last area in Massachusetts that we needed to touch on was the Karen Reed civil wrongful death case. Remember, John O'Keefe's family members had sued, and I will link the video where I covered that initial filing down below. But it was ultimately stayed during the criminal proceedings. And now that the criminal proceedings are over, the stay has been lifted and the civil case will be moving forward. And it did that with Karen Reed filing a motion to dismiss, which other defendants joined. The other defendants in this case are the bars that are being accused of over-serving Karen Reed, which is going to be difficult given all the trial testimony and video indicating that those around Karen Reed did not perceive her to be overly intoxicated, including those that were not drinking who were around her that evening. So the testimony in trial 2 of Karina Kolakithis is pretty key for the bar establishments that are being sued for over-serving Karen Reed, when those that were sober and interacting with Karen Reed said she didn't seem to be that intoxicated. And if friends who interact with her regularly don't perceive her to be intoxicated, how is a bartender to perceive her as overserved? So Karen Reed has filed that motion to dismiss. A court date has not been set for that hearing yet, though I'm keeping an eye on it. And we will go over all of those filings together. Karen Reed's motion to dismiss, the opposition to the motion to dismiss, and then the reply. We will go over those before it goes to hearing once a hearing date's set. Also, at the very end of August, we knew this was coming, but Alan Jackson, Elizabeth Little, and other attorneys have officially filed their motions for pro hoc vice to be brought into the civil case. So the civil case has quite a lot of attorneys on file. That does not mean that Alan Jackson and Attorney Little will be present at every single hearing in the civil case, but they will be a part of the civil case, which we knew from other interviews that Alan Jackson had given. So in all of the things, Karen Reed, the civil case is still proceeding. It will need to go to hearing on the motion to dismiss and go forward from there. So that is a case I will be keeping an eye on, along with the Brian Walsh prosecution and others, because the discovery issues in the Walsh case, though they are their own discovery issues, the light being shown on them as fallout from the Karen Reed case really can't be understated, especially as it comes to the continued taint of former trooper Michael Proctor being involved in these cases. Because in the Walsh case, in the King case, and others, they are going to have to ask jurors how much they know about the Karen Reed case when they start going forward to trial. And remember, Brian Walsh is accused of killing his wife, Ann Walsh, in Massachusetts, and his trial is set to begin at the end of October of 2025. So let me know if you've been following along with that case. We haven't really looked into it yet, but I might be persuaded before Corey Richens goes to trial to take a look at another case in Massachusetts. The court hours are shorter than they are in Florida, because Florida does a whole lot of trial in any given day. Massachusetts had a lot more like sidebars and snack breaks and long lunch breaks and done by 4. Florida was like, we're going to do a full court day of like 9 hours of testimony. It's a whole different world. Let me know what you are interested in the comments. We have a bunch of travel coming up, so stay tuned on the Law Nerd app. And don't worry, I have not forgotten about the Cardi B civil case. We will be talking about that on the live stream channel in the coming weeks, because yes, we are going to have to take a look at what was going on in that case. Because I know while y'all were watching trial with me in the Donna Adelson case that you were also like, but what's going on over there? Don't worry, we'll get to it. I promise. So, Law Nerd, thank you for being here. Thank you for being a Law Nerd. I will see you in the next one. There is so much more law to talk about. Stay tuned on the Law Nerd app at lawnerdapp.com, free for iOS and Android, so I can keep you in the loop with everything that's happening. More live court to come. I love it. You love it. Take care of yourself, take care of each other, and I will see you in the next one. Cheers. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.